Let me say a few words, first of all, about where my paper fits in relation to the project. Kieran asked me if I'd become involved in the project because previously I was involved in a project on the idea of the public interest. So Kieran said we're going to do a project on the question of amnesties as against the idea of prosecutions, as against the question of whether or not prosecutions are in the public interest. So my party piece is to talk a little bit about what public interest means in the context of prosecutions. The Director has already touched upon quite a few of these points, so I'll merely supplement some of the points that he had made. I also prepared, I'm never sure it's wise to do so, but I did prepare a short written paper, and I'll refer you to a couple of pages in it as I go along in due course. What is the presentation about? I'll have to remind myself. Three things. First of all, what does the public interest mean in public law? Public law is the branch of law that controls public decision makers such as the Director, such as the police, such as the Ombudsman, such as Belfast City Council. What does the public interest mean in the context of public law? I want to say a few words about that. Then I'll say something about its place in prosecutorial decision making. Again, the Director has already touched upon a variety of these points, but I'll just drill down into one or two other aspects of the place of the public interest in prosecutorial decision making. And the final point, and I suppose in many ways the main point that I propose to make today, is about the role of the courts in controlling prosecutorial choices. And the point I want to draw to your attention and indeed emphasise, and this is not in any way unique in the context of Northern Ireland, but the point I wish to emphasise is that the courts are very, very reluctant to engage in the review of prosecutorial choices, and there are sensible reasons for that. But it emphasises and underlines the extent to which the Director used the term he's trusted with power, the extent to which we as the public entrust decision making to particular public decision makers, and that drives a lot of the case law on prosecutorial decisions in relation to the public interest, and I'll come back to that point as I go along. The public interest, first of all, define it for yourself. As I was looking over my notes, I saw the exclamation mark, which probably means I'm shouting at you and saying, just do it yourselves, but I don't mean I was so excited when I was writing, you can define it for yourself, because the point about the public interest, the very first point that's made in anything that's written on the public interest, is that it is an extremely vague term. It means absolutely nothing, it means absolutely everything. It's in the eye of the beholder. It can be a good thing, it can be a bad thing. It's an obvious point about public interest, but it's an important point about the public interest. The courts themselves have said it's poorly defined, but notwithstanding the fact that it's poorly defined, and I'll come back to this point, the courts do use it all the time. It's almost like magic dust within the legal system. The word public interest arises in a whole lot of different contexts, isn't defined within context, but it's about discretion for decision makers. It's about greasing the wheels of the legal system, public interest. So it's a very vague, but it's a very useful term. That's the first point. So we can define it for ourselves and have a discussion about it. One of the criticisms of public interest, the term, is that it has an anti-democratic thrust, because essentially what happens with the idea of public interest is we take a vague term, we link it to an idea of the public. We all know we have difficulty defining the public in Northern Ireland because we have different communities within Northern Ireland and pronounced differences between them. And the argument is that the public interest becomes a rarefied term that is used to use some rather heavy-handed language, suppress individuals. The argument is that thereby assumes an anti-democratic quality. Individuals have their own interests, they're subjected to some broader public interest. But again, in law, it would be regarded as a necessary concept, because even if we all have individual interests, they pull together at some level. Obviously, in relation to something like crime, nobody thinks that individuals should be allowed to go around committing crimes. So there's a broader community imperative in ensuring that crimes are prosecuted. I suppose that's really the key question about the public interest for the purpose of today. Who should decide what is in the public interest? We'll talk a little bit more about the Director's office in a moment. Obviously, the Director decides what's in the public interest. But we may not agree with decisions that are taken in the public interest. That takes us back to the first point on the slide, because it's such a vague, value-laden term. So that's some of the background information on public interest. We have this very slippery concept, it's difficult to pin down, but it's one that is key to the whole debate about prosecutions. And the public interest in public law, I mentioned to you a few moments ago, the courts use the term the public interest. Legislation uses the term the public interest. Decision makers use the term the public interest in many ways. Multiple uses. On the paper that I prepared on pages 2 to 3, I've listed 6 examples. Perhaps I can just highlight 3 for the purpose of our discussion today. The first thing is there is a public interest in upholding the rule of law. We'll come back to the issue of the code for prosecutors in due course, where there's a starting presumption in favour of prosecutions where crimes have been committed, the public interest in prosecuting for crime. But also much more generally, the courts would talk about the public interest in the rule of law, and that includes the rule of law in controlling the decisions of public decision makers. Now, responsibility for exercising that control may fall to an office such as the police ombudsman. In some instances, it may fall to the courts to exercise the control. It's been at the heart of, for instance, representative applications in the courts where bodies go forward on behalf of community groups, bring proceedings. That's been justified in the public interest in upholding the rule of law. There's one way. The courts would also say that public bodies must act in the public interest. This is, well, perhaps it's a quaint idea in public law. I don't know how much it maps onto reality because we're all individuals working within public bodies. But the courts emphasize that public bodies should not have interests of their own, that they should be motivated by making decisions in the public interest. So you think for the greater public good, that is a requirement within public law. Public bodies act disinterestedly, they act altruistically, they act in the broader public interest. We'll all be familiar with that phrase, of course, public interest immunity, which is a rule of evidence that can be used whereby public bodies will ask the court to exclude from the proceedings before it certain evidence that is held by the public body. It's not automatic entitlement. The court will make the decision on whether the information should be excluded. But that attracts the phrase public interest immunity. That would be where one of the criticisms would be made of public interest, the term public interest, because it's sometimes said public interest in that context becomes synonymous with governmental interest or executive interest, and is that the same thing as the broader public interest? But that's, again, it's one of the definitional consequences, or sorry, one of the consequences of the lack of definition, I should say. I take one of those points and bring it forward onto this slide. The PPS, the DPP, is a public body, so therefore there's one way in which we can think about the public interest in relation to the DPP. The DPP, or the Public Prosecution Service, is a public body and must act, not in its own interest, but in the interest of the public. That's a foundational principle of public law going forward. But I want to say a few words to you about the code for prosecutors. The term the public interest, the Director has already mentioned the fact that there's a two-stage test for prosecutors. So there's the evidential test: is there sufficient evidence with possibility of securing a conviction? And there's also then the public interest test within the code. When I was writing my paper, I have to confess, I went online and I tapped in code for prosecutors, and I just crossed my fingers and hoped that the correct code came up. It's the most up-to-date one. It was from 1923. No, it was 2008. I hope that's the correct one. But if you look at the at pages 4 to 5 of the handout, the code emphasizes that there is a public interest in prosecuting crime, and that's the starting point. And the code identifies some of the public interest considerations that will be taken into account when going forward for prosecution. The code then also lists considerations, public interest considerations that may lead the office to decide not to prosecute. Those are listed on page 4. In relation to the past, and I'm surmising on the basis of what is written within the code. If you go to the 6th, Roman numeral 6, reason for not prosecuting, public interest reason would be where the defendant is elderly. Well, that is clearly something that was touched upon this morning when reference to former serving police officers, let's say, or soldiers who are in the latter years of their life. Is that a public interest reason for not prosecuting? And the 10th one, which is the top of page 5, may not be in the public interest to prosecute where details may be made public that could harm sources of information international relations or national security. When I was looking at my slides before coming forward, I did then wonder, there is the issue then about reason giving, where there's an order made not to prosecute, and that's an area where there's been some crossover with Article 2 of the Convention in the Jordan, Kelly, Shannon, McCarr cases, where the lack of reasons in relation to non-prosecution decisions became an issue under Article 2, so that perhaps provides some crossover there. So in relation to the DPP, there's the public interest, powers are entrusted, decisions must be taken in the public interest, and then there are public interest considerations. What do the courts say in relation to prosecution decisions? The rule of the courts, as I mentioned at the start, it's a limited one. The courts, and this is a limited rule in relation to the decision whether or not to prosecute. Why? Because the courts have emphasized and recognized the complexity of the decision-making process for the Public Prosecution Service. The Director mentioned the interests of victims, mentioned or alluded to the interests of the defendant, mentioned the public interest. I think it's sometimes said that there's a triangulation of interests. That means that the decision-making function that is given to the Public Prosecution Service, to the DPP, is an unusual decision-making function. It's not one that has easy comparison. It's complex, and the court said they won't therefore look closely or readily at decisions. There are many cases on the point. Those are some of the threshold that would have to be crossed before the courts will intervene with a prosecutorial choice. The courts will intervene rarely, in exceptional circumstances, where there is dishonesty or bad faith. In public law terms, an allegation of dishonesty or bad faith on the part of a public decision maker is regarded by the courts as a very grave charge, a very grave allegation, very difficult to establish in practice, and they're rarely brought forward. There's a very, very broad discretion entrusted to the DPP, to the PPS. I'll not take you through all of these cases, of course not, but those are some of the leading authorities on prosecutorial discretion and on the court's reluctance to look closely at decisions. Shukar's application from 2004, which was about, there was a decision taken by the Attorney General who decided not to deschedule charges, and the courts emphasised in that case they wouldn't be engaging in any close look review of the decision. Rhys Arthur's application, 2010, which was an application of Rhys Shukar. And the Corner House case, I will take a moment to tell you about Corner House because it illustrates the point that this approach to prosecutors is not something that is in any way unique to Northern Ireland. It's something that happens elsewhere. Corner House was a case that arose in England and Wales. In the Corner House case, the applicant Corner House Research is a pressure group, public interest group. Corner House had challenged the decision of the Director of the Serious Fraud Office, so it's analogical to the work of the DPP. The applicant challenged the decision of the Director whereby the Director had discontinued an investigation into allegations of corruption in British Aerospace's dealings with Saudi Arabia. Word came across the Director of the Serious Fraud Office's desk that there were allegations, credible allegations of corruption in the dealings between BAE and officials in Saudi Arabia. And the Director initiated an investigation under the Criminal Justice Act 1987. It would now be under the Bribery Act of 2010, but it was under the Criminal Justice Act 1987, and was essentially looking to prefer proceedings against the officials who were involved, and against BAE. Now, as the investigation was going on, a telephone call was made. I'm sure this isn't quite how it happened, but it makes it sound moderately interesting. A telephone call was made from Saudi Arabia, which basically said, we understand that there's an investigation going. This is very interesting. If you continue with this investigation, we're going to withdraw our cooperation with the United Kingdom on matters of international security and on anti-terrorism. And the phone went down. And there was a bit of toing and froing, and the Director decided, in the light of that he would end his investigation. He said, I'm ending the investigation, and again, you'll see the flexibility within the term public interest. He said, I'm ending my investigation because of the public interest and public safety. The phrase that was used in the judgment is British lives on British streets will be put at risk. And he said, well, this is obviously not something that we want to countenance. So ended his investigation. Corner House challenged the decision to end the investigation because they went back and they said, well, what about the public interest in the rule of law? Surely the rule of law will require the director to continue to investigate to ensure that the rule of law is upheld. So you had on the one hand public interest in public safety, on the other hand public interest in the rule of law. In the divisional court in England and Wales, the applicant won the case, and the divisional court said, well, the director has effectively given up his discretion by making the decision to discontinue the investigation. He's therefore effectively done away with what he's meant to do with, and that's unlawful. But it went to the House of Lords, and the House of Lords emphasised in the case, and if you read the judgment, the House of Lords emphasises the breadth of discretion that is given to public decision makers, to public prosecutors, and the difficult decisions that they take. And they said basically the director had been put in an impossible position. You get a phone call saying we're going to withdraw cooperation, we don't stop this. They said, well, this is an impossible situation. And Lord Bingham, he went on, he said the director was confronted by an ugly and obviously unwelcome threat, and he had to decide what he should do. The issue in these proceedings is not whether his decision was right or wrong. The courts aren't interested if it's right or wrong, it's whether it's lawful. The issue for us is whether the decision was a decision that the director could take, and in the opinion of the House, the director's decision was one that he was lawfully entitled to take. So Corner House, outside of the context of Northern Ireland, but directly related to the issues that would face the prosecutorial choices, very, very broad discretion, and the courts won't second guess, and certainly won't second guess readily. So what does this mean in relation to the past? I'm obsessed with 3 points. For some reason, I've brought up 3 points, I don't know how many times. But anyway, 3 points, prosecutions in the past. Well, these are therefore squarely matters for the DPP, PPS. That role has been entrusted to the office. Now, it was mentioned this morning that prosecutions in relation to the past should be a fairly infrequent occurrence, but they are ultimately matters for the office of the DPP, which has been entrusted with very broad powers. Decisions that are taken in the public interest, the director said that he's only refused one prosecution, which wasn't in relation to the past, for reasons of the public interest. Decisions that the office may take in relation to prosecutions, so not to prosecute, for reasons of the public interest, they may be controversial because, again, we have different views of what is in the better interest of society and what is not. They may be controversial, but the way in which the courts will approach it is that it's highly unlikely that the decisions will be unlawful. The courts will only step in extreme circumstances. And I wonder, is this a good example of, going back to our discussion of the law stepping back and allowing things to work out in a different way? So thank you very much.